Good afternoon, everyone. Thanks for being with us for this last session of the day. Did y'all enjoy your lunch? Okay, everybody ready to go? So one thing that CRB members, I feel, are fairly good at is kind of rolling with some last-minute changes. And staff is pretty good at that, too. And one last-minute change we had was Walt Goulet was going to be our lead presenter for this Finding 5 presentation. And Walt threw his back out, as you heard yesterday, and so we're kind of rolling with it. So my name is Molly Johnson. I'm a review specialist with the CRB. I have 3 of my own boards in Marion County, and then I am pleased to say I cover boards throughout the state, so I know a lot of you folks in this room. This is...
I'm also with CRB. My name is Sam Tasman, and I'm also with the Citizen Review Board here in Lane County primarily, although previously I was in Marion County and other counties covering part of the state much as Molly does, so I'm familiar with many of you.
So I'd like to introduce to you Sherry Mason, and Sherry's going to be our lead presenter today. Sherry has a wealth of experience with the CRB from 1986 to 1993 as a volunteer, as staff from 1993 to 2009, and then moving into her current position with the Juvenile Court Improvement Model Training as a model training analyst in 2009. So we're so pleased that Sherry was able to cover for Walt and help us out today. And Sherry, I'll leave this up. Oh, actually, let me go over some quick housekeeping. This is being videotaped, as you know, which is probably why my hand's shaking just a little bit up here. So the way we're going to do this is we have a PowerPoint. There's 3 different breaks in the PowerPoint where we'll have some small group discussion at your table and then a larger group discussion. And then we'll also be fitting in a 20-minute or so cookie break for y'all to kind of get a second wind. If you do have burning questions, we just ask that you wait until we can get a microphone to you. And you also have some note cards on your tables to jot down questions too, so you can remember those. All right, Sherry, thank you.
Good afternoon. You're the real diehards here at the very last session here. Molly told you about my experience with the CRB. I started out as a volunteer, just as many of you in this room, before I came on staff, and now I'm with the Juvenile Court Improvement Program. But that's only part of who I am, just like all of you. I'm the mother of 9 children and 11 grandchildren. I adopted a child, my niece, who was born methamphetamine affected, through the agency. So I know a little bit about the adoption process, having gone through it myself. And I'm raising my grandson. I'm his legal guardian, and I've had him since birth. He's 12 years old now. So I've got to experience the system in a really real way. And I think that's really important, that we all realize that the people on the other side of the table are real people. I think we had that told to us several times today, that these are just folks like you. So I want to keep that in mind when we're going through this PowerPoint. The finding that we're going to concentrate on today is finding number 5. And boy, is this one a mouthful. DHS made reasonable efforts in accordance with the case plan to place the child in a timely manner and complete the steps necessary to finalize the permanent placement, including an interstate placement if appropriate. Whew. I've tried to break this down, and I'm a big fan of colors. So I've tried to separate the different parts of this particular finding into colors. Before we start talking about the finding itself, you need to know that this finding is only made when the court has changed the plan, and it's no longer reunification. DHS may have decided that they're going to implement or have staffed the plan. They may come in and say, I've staffed it with the LAS, or we've talked about this and we're changing the plan to adoption or guardianship. But until the court has changed the plan, you're still going under the plan of reunification. So that's the first thing that you need to know about this finding. So there are 5 key terms that you need to prepare for when you're making this finding. The first is reasonable efforts. Does everybody in here know what reasonable efforts is? It's never been defined. No one has ever defined reasonable efforts. Several years ago, the CRB did a joint principles and expectations document with DHS. Have any of you ever seen that? Okay, you can go on the website and find it, but they described reasonable as sane, and effort as a try, a really hard try. We're going to explore reasonable efforts a little more. The second, you want to go back, Molly? The second key term is case plan. It says in accordance with the case plan. So we're going to talk a little bit about what that is. Then it says place the child in a timely manner. And then take steps to finalize the permanent placement and ICPC if appropriate. So we're going to break it down into each of those sections, and we're going to start with reasonable efforts. One person identified this in some of the research I did as efforts to provide services that meet the needs of the individual child or children and family, that preserve safety and well-being, and that implement the permanent plan. That's a lot of words. It's efforts also that address existing CRB recommendations and court efforts. I want to bring this down a little bit to a more realistic situation. I said that I adopted my niece, who is now 14 years old. When she was 10 years old, she was all into American Dolls. And in New York City, there's a big store that's all about American Dolls. They have plays, they have every American doll, every accessory that you can expect. They have everything. It was her burning desire to go to the American Girl store in New York City. Now, me as the parent, DHS is the parent in a regular situation, me as the parent in this situation, what would be a reasonable effort for me to see that she got to New York City? Okay, I'd have to plan, wouldn't I? I'd have to start saving my money. Would it be a reasonable effort to say, well, that would be really nice, but we don't have the resources for that? Would that be a reasonable effort? Maybe realistic, but is it an effort? No. But starting to save a little bit of money each bit in time might be steps towards that. What else would be a reasonable effort?
Well, there's one in California. How about if we go there?
Okay. So we don't have the resources to go to New York. Maybe we can go to California.
Don't you have to determine the word needs? Does she really need that?
She doesn't need this. And I'm using this as an example to try to get to what reasonable efforts are. But no, she didn't really need that. In her mind, she very much needed that. But if I was to try to say life and death, she didn't need to go to New York City. But, you know, I'm a good mom, and I wanted to make an effort to do that. What else would I need to do?
She would need to know what the plan was so that she can be a part of it.
Exactly. She would need to be involved in that decision. Okay, that's part of reasonable efforts. Parents need to understand what's expected of them. They need to be part of the planning. They need to be involved in the decision making. What else might be reasonable?
Determining cost.
Determining the cost. Okay? What needs to be done? How are we going to do that? Realistically, it took me a year to plan for and get her to New York City.
It might be reasonable to say, well, honey, if you save $300 or whatever, you know, she should have some stake in it.
Right. But I'm judging my efforts at this point. What were my efforts? What else would I have had to do?
You give up something that's a cost saving in a household to put away as money.
Okay.
You give up cable or your cell phone.
Okay.
And how many other kids did you have? You gotta cover them. Travel plans.
Travel plans. I had to have a plan. We couldn't just go out in the car and get in the car and say, okay, we're going to New York. I had to have gas, I had to have a map, I had to go to the airport and have a ticket.
I guess you would have to be committed to doing
Yeah,
the work to get yourself there.
right. This was important. It was something that I needed to be committed to doing. So, yes.
Oh, I was just gonna say, you put her need or desire in front of what you may want to do instead.
Yeah, looking again at her needs, looking at the need. So that's kind of a silly example, but it's something that really makes you think about what are the efforts that are being taken, and are they realistic? I mean, I could say we don't have the resources. I could say, I don't have the time to do that. I've got all of these other kids and work and other things that I have to be doing. I don't have the time to do this. It would be nice, but I don't have the time. But to really make an effort, I'm going to have to do something. I'm going to have to plan. I'm going to have to realize what it is, etc. One thing that I want to point out on that last slide is that it does not apply, this finding, does not apply to active efforts. The Indian Child Welfare Act only said that you needed to make active efforts to prevent removal and to reunify the family. This new finding came out of ASFA, and it did not appear in the Indian Child Welfare Act. So even if it's an ICWA case, you're going to be making reasonable efforts when it comes to this finding. Okay, so making reasonable efforts in accordance with the case plan. What is the case plan?
Are you still referring to your daughter?
No, I'm not.
The jurisdiction of the court.
Yeah, what the court and DHS has set up as what needs to be done, or the attorneys and the action plans.
Okay, so part of it's the goal. Is the goal adoption now, or is the goal guardianship, or is it APPLA? Because those are the three plans that are covered under this finding. But it's more than just the goal. The case plan is more than just the goal. It's all of the things that go into what you're going to be doing in the case. And if you want to go to the next slide, Molly, we'll talk about that. So the case plan can consider those family and team decision meetings, because when the family comes together and makes a family decision meeting, they come out with goals. They come out with things that are going to be done. That's part of the case plan. The health and education record of the child, that's part of your case plan. The 333 that you get, that's part of the case plan. The visitation plan is part of the case plan. So is the child safety plan, and if the child is 14 or over, the youth transition plan. So there are a lot of things that are covered under the case plan.
When you say youth transition, are you talking about IOP?
Yeah, there needs to be, when a child becomes a certain age, there needs to be a plan, and you may know them as the transition T1 or T2 plan, where they're planning for all of the domains that the child's going to need once the child leaves the agency.
Very rarely see that at my board.
Well, it needs to be something you need to be asking for if the child is at that age. Yeah. So all of these things are part of the case plan. So if my case plan is adoption, and my family decision meeting says that I'm going to be providing transportation, that DHS has taken on the role of providing transportation to get the child to therapy. And if my case plan says that there will be visitation with the children, between the siblings, that's often a part of a visitation plan, or with the parents, and the transition plans that this gentleman, Jack, mentioned, I need to be making reasonable efforts in accordance with all of those things, in accordance with the case plan, all of this planning. So my efforts need to be directed to all of those different things. Next thing says, place in a timely manner. In accordance with the case plan, place the child in a timely manner. Okay, that's more than just a goal change. That's steps to place the child in what's going to be their permanent placement. It's within expected time frames. So let's say that the court have changed the goal to adoption. We come to a review 6 months later, and we haven't begun recruitment efforts. Are we placing the child in a timely manner? Have we made reasonable efforts in accordance with the case plan to place the child in a timely manner? No. You know, lots of times when the goal changes, the expectations change. The agency's no longer working diligently with the parents and try to effect reunification. They now have a new plan, but their work's not over. They've got to do all the things that are required in an adoption plan or a guardianship plan or an APLA plan. The next part is finalize the permanent placement. So we've made reasonable efforts in accordance with the case plan to place the child in a timely manner and finalize the permanent placement. What do you think is important about this part? Finishing it, getting to the finish line, getting to the goal line. How often do you see cases that have been in the adoption plan for review after review after review? Often? Finalize the permanent placement. Have you ever heard a worker say, well, she's in her adoptive home? Is that finalizing the permanent placement? No, the child is still in foster care, still in DHS custody.
What we hear is there's only one adoption worker, and he's backloaded, stacked up.
In your particular branch? Okay. So, reasonable efforts in accordance with the case plan to place the child in a timely manner and finalize the permanent placement. What should you be doing in order to move the case along? What can you do? Know the timelines. You know, Michael Livingston said something really interesting yesterday. He says, what is important is the inquiry. What does that mean? Asking the questions. What kinds of questions can you ask? Where are you in the process?
Send in all the paperwork. What are they waiting for something you don't have? When was the last time you called them? I mean, all those, yeah.
All very good questions.
What's the next step?
What's the next step? What's the barrier?
We had asked fosters who were potential adoptive resources, has it been explained to you, the full process? Well, I think so, but they're not real sure of the whole process of adoption. What does that mean? You know, and to them now, they're just going along.
Mm-hmm.
So for them to really understand.
So, what would a reasonable effort be in that case?
Caseworker to make sure that the adopted family understands the full impact and the steps they have to take.
Right. And for the caseworker to know that. Molly? So what you do is you ask the questions, you note barriers in the findings when you're told that this is happening or the reason that it's not moving forward is because of this reason. And you make an effort to move the case forward. I'm going to suggest that you have an obligation to make a reasonable effort. You need to make efforts to move the case forward. You need to ask those questions. You need to note those barriers. You need to know the process. You need to follow up on those issues. Don't just say yes because the goal is implemented. Now it's adoption, so we've made reasonable efforts. No, the court changed the goal. That's not an effort just because the plan has changed. Or
I think where we realize our frustration is that it's subjective as to who's judging. If we ask a question, and because of every case being so individual, we don't have, well, this needs to happen in 6 months, this needs to happen, you know, it's not defined like that. So you see a situation where your difference of opinions is coming in. What's reasonable to me may not be reasonable to the caseworker or other people.
who makes this finding? Who's making this reasonable efforts finding? You are. You're determining what's reasonable.
Well, we've all been told that, well, we can't do that because that's just not how it's done. By a caseworker.
Well, the caseworker's not making the finding. You're making the finding.
Ultimately, you know, we will make the finding, and it's generally not in that kind of attitude's favor. However, there is still is anything actually going to be done until the next time it's reviewed by somebody? And, I mean, it can go on and into infinity if
It can. It can. And that's why it's important for us to move the case forward. We're going to talk a little bit about adoption, particularly. And then we're going to cover guardianship, and we're going to cover APLA. But we need to educate ourselves. The judges are educating themselves about the adoption process. We need to know what the steps are so that we can tell whether the case is moving forward and whether reasonable efforts are being made in a timely manner. The last part of that finding is including an interstate placement if appropriate. So first of all, in order to ask that part of the finding, you have to determine whether or not it is appropriate. Is it appropriate for the child to be placed in New York? Maybe it's totally appropriate. Maybe they're very much bonded to where they are, to their support network here in Oregon. They may need to, maybe the interstate compact hasn't approved the home. So we wouldn't want to be placing there. That's okay. So you're going to consider efforts to identify the permanent placement. That's the first thing they have to do. They have to find a placement and make it timely, place the child timely. Then they have to make an effort to place the child in that permanent placement, transition the child, and then finally make the efforts to achieve finalization of the permanent goal, the adoption. I know that when I went through the adoption process, I was much more concerned with finalization of the adoption than the agency was. Why is it important to finalize the placement? Legally, there's a legal, you become the parent when the adoption is final. There are lots of things that can be affected until the adoption is final. For instance, I have a son that lives in Camas, Washington. I couldn't take my daughter whenever I went to visit my son without getting permission from the agency to go across the state line. Yes, she was in her adoptive placement, but the plan wasn't finalized. Lots of examples like that. Okay, so you're going to look at the efforts. You're going to determine whether or not they were reasonable during that review period. And then if they were, the finding is yes. And if they were less than reasonable, then the finding is no. Seems simple, right? Okay. You want to go further on to the next one? Okay, so let's talk about what needs to happen in adoption. The first thing that has to happen in adoption is the child has to be legally freed. That's the freeing process. And that can either happen through relinquishment of parental rights and designation of the placement, or through termination of parental rights in court. In order to go to termination in court, there has to be a legal assistance referral written. There has to be a TPR petition filed. A trial needs to be docketed and occur. And the judge needs to sign the order.
How long can a process like that be expected to take?
We're going to talk about that, okay? So, when the plan is adoption, reasonable efforts towards adoption include steps taken to find an adoptive family for the child, to place the child with the adoptive family, and to finalize the adoption. All those three parts that we talked about. First thing in attempting to find a placement for the child is to search for an attempt to place with relatives. And we've talked about this throughout the day. Many, many people have talked about the importance of continuing the relative search and trying to place children with relatives. Sibling planning is another step that needs to be taken. If the children are going to be separated, there needs to be a whole different process to look at that and determine whether or not it's in the best interests of the children to be separated. Otherwise, The siblings need to be placed together. There needs to be child-specific recruitment efforts. And these are really, really important. It's not just putting out there a waiting child bulletin and there's no response, and so we're done. There's lots of organizations that are very good at doing child-specific recruitment. You have one here in Lane County. A Family for Every Child in the Heart Gallery does child-specific recruitment. After you've recruited families, there needs to be an adoption home study. That can be an updated study if they're with a current caretaker or a relative that they've been with who had a family foster placement. They can update that to an adoptive placement. Then there's a whole selection process. DHS changed their rules about adoption recently. The caseworker can now make that decision on their own with the supervisor in certain instances. It doesn't always have to go to committee. There can be local level committees. There can be central office committees. Those selection processes in local office and in central office now are made by something that's called an adoption decision specialist. Once you have selected a family, there needs to be transition and supervision services to transition the child. And then finally, adoption assistance needs to be established, and we've heard that that's one of the biggest issues that you run into. After that, there needs to be the adoption registry. The adoptive placement has to be designated. There has to be a consent to adopt. The adoption petition has to be filed, and then we finally get to finalization. So there are a lot of steps in the adoption process. So what are the timelines? In a relinquishment case, if the parent signs the relinquishment forms, within 1 month, they should be able to do a mediation referral, if that's applicable, or send recruitment materials to central office, or send the adoption planning summary to central office.
Just a quick question. On relinquishments, can parents do a relinquishment designating the current foster placement or make any input or
They can sometimes have input. It can be a mediated agreement, but they don't take relinquishments where the person says it has to be with a specific family. That decision is up to the agency. Here's a list of all of the things that need to go in order for an adoption to be finalized. You can see that there's a lot of them. That's where concurrent planning comes in. So important. They should have the birth certificate from the very beginning of the case. We shouldn't be waiting until we've changed the goal to adoption to make sure that the birth certificate is in the file. We should be finding the father long before we get to adoption. We should be doing diligent relative searches. All of these things are things that you as CRB members can be very, very helpful in when you're doing, especially if adoption is a concurrent plan in the case. What are we doing on the concurrent plan? This is going to be on the website, all of these materials. Another thing is that there's a form called the DHS CF 450. If you go on the DHS website and get the CF 450, It lists all of the things that have to be in the packet before they can start adoption assistance. I just met with central office a couple of weeks ago, and I found out that they no longer have to send stuff back and forth to central office paper-wise. In the new ORCID system, they have what's called a file cabinet in ORCIDs. And the caseworker can begin to put these individual documents in the file cabinet. And then central office can pull up the file cabinet and determine whether all of the things are in there or not. There are certain things that they have to have that are the original copies, like the birth certificate that may need to go to central office. But a lot of this sending paperwork back and forth is no longer going to be a barrier. Anybody should be able to look on the computer in that file cabinet and know what's missing. That's an important piece of information for you to have. Because if the caseworker comes in and says, I don't know what we're waiting on, have you looked at the screen? What's in the file cabinet? What's missing?
Does CRB have access to that?
To the file cabinet? No, you don't, but they can print off the screen, or that you can start training caseworkers to look at that before they come to your reviews so that they can tell you what's missing from the file cabinet. Yes, you should have a copy of the birth certificate in the child's file. That's one of the things that's required in the child's file. Mm-hmm.
I believe the CASAs have access to these files by law.
The CASAs do have access to the files. Okay, you want to go to the next one? So in a relinquishment case, it should take about 2 months to do the preliminary current caretaker staffing. Within 4 months, the adoption home study should be completed, families selected, and the adoption committee requested. This will all be on the website. Adoption committee scheduled. After adoption committee, it'll be 1 to 6 months for formal designation, because if the child's being placed in a home that's new to the child, there has to be a 6-month supervision period. If they're with their current caretaker or relative they've been with all along, they don't have to wait that 6-month supervision period. 3 months to complete the adoption assistance application, 6 months, and these are general time frames, okay?
Back to back, or these can be going on concurrent?
Yeah, they don't have to go in any particular order. There's a chart that DHS has that's called the adoption process timeline, and it lists all of these different steps of things in order that have to be done in the adoption process. This one was developed in 2011. I got it from central office. We're having them update this with timelines. The old one we used to have had timelines in each one of these steps. This one just tells the steps. So we're working now to do that, and we can post that on the website and make that available once it's done. The judges are very interested in the adoption process as well, and they've formed a work group that's working on the adoption process. So you're going to hear a lot more from your judges probably about adoptions and reasonable efforts in adoptions in the near future. 12-month placement policy versus best interests of the child versus federal 24-month guideline. What this slide means is, how long do we give parents in order to do the expected outcomes that we want them to do? 12 months. Okay. How long from The permanency hearings it's from the time that the child enters care until 12 months, the permanency hearing occurs, okay? And again, there are time frame differences, but we give them 12 months. How much should we give the agency once we've changed the plan from adoption to finalization?
From adoption, you mean return a parent to adoption?
Mm-hmm.
Okay. How much should we give them?
Yeah. How much do you think would be reasonable? What's a reasonable effort? It seems like if we're only giving parents 12 months, that we ought to be able to complete an adoption in 12 months, don't you think? Well, the federal standard, is that 32% of the adoptions should be finalized within 24 months of a child entering care. So that's the national federal standard. A third of all of your cases should have the adoption finalized 24 months from the time the children are entering care. Is that happening? What happens if they don't? The child languishes in care until the adoption gets finalized.
Two-thirds can take more than 24 months.
Yeah, realistically, there will be a certain percentage of them that take more than that.
How do we get that figure, though? We only see one family at a time, so we wouldn't...
Well, you do, but, and I think it's about 36.5 months right now. Don't quote me on that. That's just the median time I think that it's taking currently is around 36 months. From the time a child enters care until their finalization of their adoption.
Do you think there's any chances close to 32% that happens?
I think we have a way to go. And I think we need to be considering carefully whether reasonable efforts are being made to place the child in a timely manner and finalize the permanent plan.
I don't see how we can get that figure from our county if we as CRB people only see one family at a time.
How many adoption cases do you see?
Well, 2 days ago, we saw 2.
Okay. How long had those been taking?
5 years.
Okay. So you're probably not meeting that standard in your county. You can get child-specific data from the DHS website too. There's something called, what are those things called that they post every month?
There's a dashboard report on the DHS website. So if you go to the main DHS page, and if you look on the left, you'll see data and reports. And if you click on that, it'll bring up a new page. And if you go all the way down to the bottom of that page, you'll see CAF dashboard. And they're by year and month, and you can see lots and lots of data in there that is prior to August of 2011. Because they haven't been able to update any of the child welfare data since they turned on Orchids last August.
Okay, so in a termination case, you'll be able to see on this PowerPoint when you look at it later what some of the timelines are and what some of the things need to be done within time frames. And again, these are just general time frames. These aren't specific time frames, but at least it gives you an idea of how much time things should be taking. You want to go back to that last slide, Molly? Reminder, if the child has been legally free for 6 months, so they've been legally free, they've gone through either the relinquishment or the TPR has occurred for 6 months and has not been placed for adoption, or DHS has not initiated the adoption proceedings, a permanency hearing is required. This was a law that was passed just a couple sessions ago. Okay, so we have some scenarios on your table, and Molly's going to lead you through a process to look at an adoption case.
Okay. So what I'd like to ask you all to do in the first place, if you could, is if there's only a couple of you at some tables, you might want to join another table so we have maybe 5, 6 folks at each table. You have 3 different scenarios on your tables, and we'd like you to look at scenario 1, which is the adoption scenario. And read through that scenario. There's some questions, a few questions down on the bottom. Maybe have one person at your table who's willing to kind of report back to us. Sam and we're planning on coming around and helping you with that. We'll take about 15 minutes. And while you're having your group discussions at your tables, we'll go ahead and turn off the video, and we'll come back on for our reporting in our large group. Okay, how's everybody doing at your tables? You need more candy? Well, you know, I just took a short walk in the hallway and I can smell some warm chocolate cookies out there. So how about if we do a little reporting in at our tables and then we'll take a break, right? That's our schedule, right, Sam? Okay, all right.
One general question. Quite short and don't include everything. So can we assume if something isn't mentioned, it doesn't exist, like siblings in this case? Or in one case, the father isn't even mentioned. Can we consider he's not a factor in the case?
I think that it's very reasonable to maybe ask one of those questions. Maybe those would be one of your questions for the caseworker. Does Ronnie have siblings? Is there a reason the sibling group is not together? Was there a sibling split? Was there, but
if we get into that, there's all kinds of
that's why we tried to keep them really short.
Right. For the purposes of this exercise, assume if you don't see it there, it's not there. It's not to focus on. Yeah. For the purposes of this exercise, let's do that.
That will make it easier.
Yeah. Just wanted to show.
Cookies don't cool.
Yeah.
Right.
So, what are some of the questions that people came up with? So we said let's have each table designate somebody to share with the whole group. So how about this table? As to what are some of the questions that you came up with that you would ask during this review?
Okay, so I'm sorry, what's the question?
So,
you just want us to do the 3 questions?
right. So what kind of questions?
Okay, so we're interested in finding out if a petition for termination of parental rights has been filed. We're concerned about the status of the relinquishments and if they're dependent on particular relative placement. And that looks like it's held up a little bit right now. It hasn't been decided, so we want to know that. And secondly, we want to know where they are in the process of determining which relative they're going to place with and how they're going to make that determination. If there have been any visits with those relatives or what the child's previous relationship with those relatives are. Any others?
Asking Ronnie what
does he want?
he thinks is best for himself.
Thank you. And that is a common thread. That was a question that I think most of you had. What does Ronnie want? And does he have any relationship with those relatives? The question about how they file for TPR, that's a very good one. We have parents who are expressing an interest to relinquish, but we can't rely on that. So how they file. We know that the court changed the plan November of 11. So very good questions. How about any other questions, by the way, that...
Well, they're all the docs in the file.
Right, exactly.
It seems like the father is not saying it has to be his relative. The father's just saying it has to be a relative. Is he okay with it being the maternal aunt? And I'm guessing if he was okay with that and that's what the mother wanted, they'd both relinquish.
No, but she can't defend it. They can't hold them hostage, the adoption hostage for their preferences and that case.
But it is possible. I mean, I think we've all been in those reviews where one parent will say, yes, I know the other family members and I'm very comfortable with them. You're nodding. So we've seen those cases. So it is possible. How about major issues that you need to know to make the finding?
Well, I think we need to know whether the mom will refuse to sign the TPR if the child doesn't go to the aunt. In other words, is she forcing it so that that's the only placement that he can go to with the permission of both of them? Or would she agree, now that she knows there's a person out there that he could go to and let him, be involved in making the choice?
And that's why the question from this table is very critical. How they filed for TPR. Say that again?
The involuntary termination has to be filed.
Right. They can't assume that the parents will, in fact, relinquish. They need to file. The court order the plan be changed, so they need to do that.
You asked if there's any concerns that you might want to bring up, and one of them is that sometimes families, when they do the ICPC, they're not telling the family if the child has high needs or special needs, and so that may change. So with whether that relative is willing to take the child. So I guess if there's any issues with the child, has that been shared with the potential adopter?
Exactly. We don't know if, we've read that Ronnie has improved, he's doing better, but we know that sometimes those issues come up and caseworkers need to share that information with their relatives so that they can then decide whether that is something they want to continue doing.
Yeah, I can't see how this case can move forward at all until the parents have relinquished. And the mother conditionally relinquishing is dictating who the child should be adopted by, and that's not her decision to make.
Right, and that's why, going back to the question on that table, very critical how they filed for TPR. And if not, why not? And which is to say, for the next thing we want to address, what recommendations would you make? How about this table?
Well, that it be taken to the Central Office Adoption Committee.
It may rise to that level, absolutely.
But they can't do that until Ronnie's freed, which he hasn't been.
Right.
So my recommendation would be make sure Ronnie gets freed. Do what you need to do.
So the recommendation would be filed for TPR as soon as possible. How about this table over here? Recommendations.
Covered everything we've talked about.
Okay.
Also, requesting that the therapist, if Ronnie has a therapist, for the input to be provided by the therapist specifically and get into the records.
Right, and very good point. Oftentimes we have therapists attending reviews. We could ask them, Or if not there, that could be a recommendation. DHS, talk with the therapist. What's the therapist's position?
So that's a family decision meeting.
I'm sorry?
Family decision meeting.
Not necessarily.
At this stage, I'm not sure that would be necessary, but it could be. So,
For sure, I would ask if Ronnie has any relationship with either one of these two relatives. I mean, that's not necessarily a recommendation at this point because I don't know, but that might make a huge difference. And also, as they said, what does Ronnie want? He's 11 years old. He should have some say.
Well, and also remember early in previous reviews and in an earlier finding, you would have discussed about relatives, you know. So perhaps he all along had been maintaining contact. Or maybe they knew about these relatives who, as far as we can tell, are very appropriate, and there were no efforts to foster that relationship.
I just
Good
have
questions.
a question to clarify. When it goes to, so the parents haven't relinquished yet, but the case is, the plan is adoption. They'd have two IP. It still can proceed to the adoption committee, can it not?
Not until he's free, right?
Can it? Oh, it can't, not until he's.
Until the parents don't have rights.
You wouldn't be going to adoption selection if the child wasn't even freed yet. So the child has to either be free by termination or through relinquishment.
Even though they have elected two placements that have shown interest.
Yeah, but it's still concurrent.
Only one possible adoptive family approved. Then he could go there as a foster placement, awaiting the adoption. But
That is possible. And at this stage, that's what it looks like. You know, they have been approved through ICPC for placement.
But there's two in this case.
Right, and then, so that's what they need to figure out. And the two questions that were very, very important: what does Ronnie want? Does he have a relationship with either of those relatives?
We have one more question back here.
One of our recommendations was to arrange visits with Ronnie and the designated, or either both, you know, relatives. Again, the question is, we don't know whether they have any kind of relationship with him, but it doesn't mean that you have to fly him there. I mean, you could do it through Skype, you could do telephone visits, you could exchange letters. There's a lot of things that could be done back and forth that might help make that decision. The other thing we questioned was, we might recommend some mediation done with the mother. If it was determined that the mother was really upset about this paternal relative, that maybe if they did some mediation through a therapist to help her cope with this and help her know, you know, where her son was going to be.
So, you know, good information, good things to think about as you go back to your counties and review cases, the information that was presented in the PowerPoint, as well as some of the information that's been presented through other workshops. I encourage you to go online to our website so you can review that information and talk about it with your local field staff so you can come up with questions that you can ask the parties that reviews when you're addressing these kind of issues. So with that, we're pressed on time. We'll take a break. How long a break are we taking?
10 minutes.
10-minute break, and then we'll reconvene.
Thanks, Sam. Okay, we're back with our session after a short break. Okay, we're going to start back up again now. Hope you enjoyed your break.
Okay, the next plan that we're going to talk about is guardianship. So I think it's important to note that when we're looking at a guardianship, the parental rights are still intact. We haven't terminated parental rights. There has been no relinquishment. The parent is still the parent. It's just that the custody has changed, and the guardian now has custody. So when a child is 14 years of age or older, it's very important to consider the child because the child has to agree to the guardianship. The parent also has to agree to a plan of guardianship. And we need to make sure that the child is developmentally to an age where the child can consent to the guardianship. I learned something that was kind of interesting in the last workshop that I was in. I was in the APLA workshop. And one of the things that they mentioned in that is now with the new assisted guardianship assistance, now you can have guardianship assistance as well as adoption assistance if you're not a relative. They can pay guardianship assistance until a child reaches the age of 21. Adoption assistance stops at the age of 18 for a child. So sometimes that is very important in the plan for a developmentally disabled child. It gives more time to be able to support the guardianship and to provide the assistance.
Excuse me, is that an Oregon statute or is that an Oregon?
I don't know. Is it just Oregon? I don't think so. I think it came out of the new, the most recent legislation about, I can't remember the name of it, that extended guardianship assistance. Oregon didn't used to have, it wasn't possible in the past in Oregon for you to get guardianship assistance if you were a relative, but now you can get guardianship assistance if you're a relative. So if DHS selects the substitute caregiver as the potential guardian, so say this is the foster parent that the child has been with, or they need to make sure that they've made every effort to identify relatives, because just like with adoption, the preferred placement is with a relative. We need to constantly be looking for, assessing, and developing relationships with relatives. And we also need to place children together in a guardianship, if at all possible, just like we need to place children together in an adoption. And if you're going to separate children, there has to be a sibling planning committee decision that it's okay to separate the children, just like in an adoption. So placement with siblings, placement with relatives are still high priority in a guardianship as well as adoption. In order to establish guardianship, a plan of guardianship and guardianship assistance, the foster care certification has to be current. So they may have to update the certification, update the home study. There could be several things that need to be done in order to establish the guardianship. And if the child is an Indian child, the tribe has to approve of the guardianship, has to approve of the plan of guardianship. If the guardian is not a current caretaker and they're going to move to, say they've located a relative and they're going to place the child with that relative, or if they're going to place the child with a neighbor or someone else who's decided to establish guardianship with the child, then there needs to be a supervision period for at least 6 months. A child has to have been in the placement and stable for 6 months before guardianship can be established. If they're going to be placed out of state, they need to go through the ICPC process. How many are familiar with the ICPC process? Okay. It can be another thing that's quite a holdup in some cases. Particularly in adoption cases. We didn't talk about this in the last section, but some states will not even do a home study until a child is already freed or legally freed, or until ICPC has been established. So there are rules when you're going across states that may differ from state to state. They have to have an updated home study and adequate financial resources. So there's a question on here as to why might a relative prefer guardianship? Does anybody have any suggestions about why that might be? Yeah. maybe there's, a good relationship with the birth parents. The child can't appropriately go home, but the child could be bonded to the birth parent. Don't want to terminate parental rights. That might not be appropriate in that case, and so guardianship might be an appropriate plan.
The other one is the opposite. They have a bad relationship with the parent, and they need the assistance of the state in protecting the children from the parents.
Okay, and so in an adoption, the state would be totally out of it, you're saying, and if the state maintains the guardianship. But the state doesn't, when there's a guardianship, for instance, there aren't CRB reviews anymore unless there's a special requirement. The CRB can review the guardianship, but the custody has gone to the guardian.
Well, you've already mentioned one in the financial support.
The financial support and resources, yeah, because it lasts longer.
Sometimes the child may need a higher level of care as they age, as they are older, and the guardian may be less able to meet those needs. For instance, grandparents and even in some cases great-grandparents are parenting. And as they age, the adoption may have been appropriate early, but many years later, guardianship would have been much better because grandparents, perhaps grandparents are going to need more assistance, and guardianship makes it much easier, in my limited understanding, for that assistance to be available to them.
Okay.
And if it's an equal case, pretty entirely, the tribes don't want the complete break of the parents, so they prefer guardianship almost always.
Yeah, and I'll repeat that for those of you who may not have heard it. In an ICWA case, the tribe does not believe in adoption, and so the tribe may approve a plan of guardianship, but would not approve a plan of adoption. So there might be several reasons why you're establishing a guardianship rather than an adoption, but there's still a process that you need to go through to establish a guardianship. Even a private guardianship, there needs to be a home study. You need to go to court. The court needs to approve the plan of guardianship. The assistance agreement needs to be worked out. There are many things that are parallel to what needs to happen in an adoption case.
In a guardianship, as opposed to an adoption, correct me, one way or the other, does the court review it annually?
Yes, the court, it does review a guardianship annually. Like I mentioned, I have a guardianship of my grandson. I have to, every February, make a report to the court that has to go to the court and has to be filed, and the court will look at that paper. Now, they may not call it into court, but they review that. And there is a part in the CRB statute where in some counties, citizen review boards are actually reviewing guardianship cases. Clackamas County does that. I think Marion County does some guardianship cases. Pardon? Benton County's doing it.
Where I was always really confused, because we had a field manager who originally was adamant about children going to the highest level of permanency, which is adoption, if they're not going to return to parent. And that particular field manager was adamant that a young child, there was no reason for a young child to be in guardianship, that a young child should go to adoption. And that the only cases that he could see that made sense for guardianship is an older child who didn't want to be adopted.
Didn't want to be adopted or had a bond or a relationship with It is very unusual to have a very young child in a plan of adoption because it's not considered to be as permanent as adoption. Guardianship. So for instance, say that the guardian gets severe health issues. They can say, I can't can't be the guardian anymore. Or say that they get divorced or have financial considerations or whatever. A guardianship is revocable. You're not in it for life. The other thing is a parent can always go back to the court in a guardianship and show that they've ameliorated their circumstances and get the child back. So it is considered to be a higher level of permanency because the parent, the adoptive parent actually becomes the legal parent. Mm-hmm.
Can't wait.
Well, here first.
Hold on just a minute. I have a question regarding guardianship. When the relatives are come forward and offering to be a guardian, does DHS offer them any services?
Sometimes. I think that they do offer them services in order to prepare for the transition of the child, to make sure that they have what's needs. Absolutely, guardianship assistance is a service to the guardian. Medical cards and issues are services to a guardian. There's also some supportive services that the guardian can still call up the agency and say that they're having issues with this or that or the other. So there can be assistance. Sometimes guardians don't want any assistance from the agency. They just want the agency to be out of it. So
it's not like a screening process for foster parents.
Pardon?
It's not like the process that the foster parents go through in order to be certified.
Yes, they have to have gone through certification.
Okay, that's really what I wanted.
Yeah, they have to have a home study and they have to go through certification.
As rigorous as an adoption home study?
It's more akin to I would say it's more akin to a foster home study than it is to an adoption study. Yeah. Yes, they would have to have an updated home study and an updated certification. Yes.
I had a question, but I think she had one first.
No, my question is, in this scenario number 2, which says guardianship, where do the parental rights fit into this picture? Because the mother's disengaged, and it doesn't even mention the father unless you want us to look at scenario number 1 and know that the father's in jail for 5 years.
No, parental rights remain intact in a guardianship.
But why?
Because it's a guardianship. You don't terminate rights on a guardianship. There's such a thing as permanent guardianship, which is a little bit different than a regular guardianship. It's very rarely used, even though it's on the statute books. And in a permanent guardianship, the parents cannot come back to the court and say, I've ameliorated the circumstances, I want my child back, I can show that I am now able to parent. But the standard for establishing a permanent guardianship is almost like having to establish the same as you would for a termination of parental rights. So it's very rarely used.
I don't understand in this scenario why we went to guardianship. That's just because...
Let's wait till we discuss the scenario. Yes.
When might it be in the best interest of the child to go up for guardianship rather than adoption?
Can we hold off on that question for just a minute and finish this part? So a non-relative foster parent can receive guardianship assistance if there's a compelling reason why adoption is not achievable. Maybe for whatever reason the child has such high needs that the parent is not, or the guardian is not willing to establish adoption of the child, but they would be willing to be the guardian because of that. What we talked about, the services that might still be available to them, and the fact that they don't hold the same legal liability in some instances either. That's often an issue. They also, if the court-approved goal is guardianship and the non-relative foster parent has cared for the child for at least 12 months, they can get guardianship assistance. A step-parent is generally considered a parent and not typically a relative for assistance purposes. Okay? So, getting to your question, which I think was, why might it be better for a child to have guardianship? Was that the question that you asked? Who would like to offer a suggestion for that? Who wants to answer that? Mm-hmm. An older child that won't consent to the adoption. Could be. Of course, you want to make sure that they've explained adoption to the child and that they've DHS, that they've had they've sat down and explained to the child what adoption is, because sometimes children don't understand what adoption is. They think that they're going to have to.
They should have counseling.
Right.
And that's something you can recommend.
That's a very good recommendation. I think that somebody back here is asking a question. Uh-huh.
I feel isolated back here. Well, I think one of the things that we always talk about with guardianship is we refer back to when families were closer together and there was a need for help, and help out one member of the family by taking their children in. And we always refer to, wouldn't it be great if they could do a guardianship because mom could still visit and mom could still be a part of this child's life.
And that's what I was talking about, if there's a bond between the child and the parent. You don't want to sever that. Say for instance, even there are extreme health reasons. Maybe the mom's dying of HIV or cancer or something. You're not going to want to sever parental rights and go to an adoption. You may go to a guardianship because there still will be that ability to be able to visit with the mom and have a relationship with the mom, even though the mom may not be able to take care of the child.
This was actually my question from earlier, and that is college assistance for the child. Is it different under guardianship, permanent guardianship, or adoption?
And you probably should be asking Rosemary Ivandetti that question, but who's doing another parallel workshop here. But it has more to do with when the child was in care. So for instance, if the child is adopted after a child is 14 years of age or in a guardianship, they still qualify for that. But like I adopted my daughter when she was had her since she was 5 weeks old. The finalization was like when she was 3. She doesn't qualify for that because, of the way the rules are.
And she had spent, many years in foster care, that she would qualify for some of these programs, and she did not. She qualified for ILP services, but she did not qualify for any of the scholarships, Chafee, a whole range of things got taken away from her by that step. And I don't know what it would be with
Yeah,
and
I think that's changed. I think that, like I said, you need to ask Rosemary or somebody that's not my area of expertise, but I think they have made some changes in that rule within the last couple years. Okay, one more question, then we're going to go to our scenario.
The type of guardianship that I'm used to is where you have a severely handicapped child, and when they turn 18, the parent or whomever becomes the guardian. If you are already the guardian of that child, can you then be that type of a guardian also?
I'm not sure that I understand your question, but guardianship assistance now can go to the age of 21. The agency can keep in the picture until the child is 21. It used to be 18 when it was cut off, and it still is for adoption, but it can go till 21 now. And I think that allows for that transition into the developmental disability system.
If a child is unable to make the decisions, the parent or whomever is responsible for the child obtains a guardianship role. But I think it's different than the type of guardianship that you're talking about.
Yeah, I think you're talking about a probate guardianship.
Okay.
There are different kinds of guardianship. For instance, I have guardianship of my grandson, but not through the agency. I established it when he was born before the agency got involved, and that's a whole different system than the DHS system. So there are different types of guardianships.
Okay, so we'll go ahead and start up on our scenario 2, or guardianship. And again, if you're at a table with only a couple of people, you might want to join a bigger table to discuss the scenario. We'll break for we have about 15 minutes, Sam? Yeah? About 15 minutes, we'll take a break.
For this scenario, assume that services to the parents have been addressed, and the court has changed the plan, so focus on the plan of guardianship.
No, yes.
Okay, folks, has everybody had enough time to look at the guardianship scenarios? So since we only have about a half an hour left, who can just tell me who can tell me what some of your questions were on the guardianship? Anybody want to volunteer?
How recently have you tried to find mom? Are you still working on that one? When do you expect to finalize this guardianship, and what's the delay? And what about the Washington relative? Is he or she still a resource? And what is Ronnie's contact included with this Washington relative? Because we're concerned the California relative isn't committed to this.
Okay.
They're willing if he doesn't have any more problems, or his problems don't escalate.
I really like what you said about how long do you expect it to take and what are the barriers to it. Because then you're getting real specific about where they are in the process.
Being slightly more specific by saying he's been there a year already, and you're saying 6 months. Why? Why is it going to take as long as 6 months more?
So we have a question here in the back.
What we're looking for is permanency for the child. Had they placed the child timely, reasonable efforts in accordance with the case plan to place the child timely, and finalize the permanent plan. So yeah, we don't want it to go on forever.
Okay. We came up with same thing about why is it taking so long to finalize the guardianship. The other two questions we had were, how often are you getting a report from the ICPC worker in California, and how often have you visited the home, and is Ronnie requiring any other services? And the last question we wanted to know was if the paternal relative in Washington was willing to be a resource or a respite worker for Ronnie.
Okay, so to offer some familial respite.
I was concerned about the relationship between the guardian and the child. Why did the grandmother think that he may escalate enough where she might have to terminate guardianship? Question rose, is there something going on in their relationship? And maybe the child and the grandmother or guardian needed counseling on how they interact.
Okay. So did the grandmother, I believe if the scenario I think was the grandmother didn't want to enter into adoption because she thought that perhaps Ronnie's behaviors would escalate, or because of the down the road what might be going on. So that's why she preferred the plan of guardianship. So you're wondering whether appropriate services have been put into place to ensure their relationship, like counseling and. Okay, good question.
We have another question here.
Yes, when Ronnie was in foster care, the state was paying for his health care, I believe. So if he went into guardianship, who would be paying his medical bills?
I don't need that other one. Yeah, guardianship assistance includes a medical card. So they would have the same kind of medical card as they would if they were in foster care. Adoption does too, yes.
It does too.
It could.
She's worried about his escalating behavior. I mean, his one reason. They're saying she could have that.
And those are good questions. One of the groups said, well, his behaviors are improving, he's doing better in school. So a question for the caseworker would be, have you talked with the relatives? Now that he's made improvement, would they consider a higher level of permanency, which would be adoption? Somebody also mentioned the relative in Washington. That's a possibility, how that discussion with those relatives.
The plan, the court changed the plan only to a permanency plan to guardianship. So there's nothing that would indicate that the relative in California had to do an adoption. And so the question would basically be, for me, is why is it taking 9 months to finalize when it should have been finalized in about 6? And are there issues or concerns that the courtesy worker in California or Ronnie's therapist see that is slowing down the process more than now let's look at adoption for him, because the plan is exactly what it was supposed to be according to the court, which was guardianship.
So you want to be asking specific questions. You know, what steps have been taken towards the plan of guardianship, what steps remain, and for a review day prior to the reviews, that would be an issue that you could talk about and formulate questions with your field staff that would address that concern. So moving on, what would be some recommendations that you would make? Having heard and discussed the case, what recommendations would you have?
Expedite the process.
We have two. Should be talking up there.
Yeah, it depends on the answers to the questions.
Yeah.
So then you would, if you don't get clear information from the caseworker, then you could perhaps ask that a hearing be set to address the delay. Ask for, specific information for the caseworker. If it's something that has to do with central office, contact central office and ascertain what the issues are, why there is a holdup. Any other from that table or?
One more back there.
We had two that maybe help move this thing along, and one of them was, had anybody done an updated home study, and the second one was, have they gotten any input from a mental health counselor on him to see if he's, like a progress report or something, to see if he's still progressing or not? So.
Okay, those are good questions. We'll take one more and then we'll go ahead and go on to our last section of the finding.
So my recommendation from ACASO, my request to the CRB on this case would be that there would probably be a permanency hearing in 3 months automatically, because it's been 9 months and it had to be every year. So I would guess that there would be one in 3 months, and that for the CRB to expedite the report to the courts so that the court had it in time for the permanency hearing.
Great recommendation. Sam? One more question back. Well, she's saying to make that recommendation for that the CRB would make that recommendation for an early permanency hearing, or the court to review the case.
Well, the hearing's probably already been scheduled for 3 months. So you could either recommend that it be moved up, or...
That's the problem. We're deciding here. Why wait 3 months for the hearing? Have it next week.
Oh, okay. So, right. Okay. So to docket docket that permanency hearing as soon as possible, but right. Oh. Right. Okay, well, let's go ahead and move into the last section of our PowerPoint now. So I'm going to hand it back over to Sherry.
Okay, so the next plan that you could be reviewing under this finding would be another planned permanent living arrangement. And this is supposed to be a stable, secure relationship for the child with significant people in their life who supports them and will be there with them after they age out of the system. Planned means intended and designed. It's a plan. It's not just going to happen. And permanent means enduring and stable. So it's really important in these plans to see what the agency is doing in order to create those relationships that are going to endure beyond the time that the child leaves foster care. It's the least preferred goal that it is, because adoption, we have established a new parent for the child. They have a new legal relationship. Guardianship, they have a permanent custodian who has making reports to the court and is committed for the child's life. Another planned permanent living arrangement is almost a default plan, and because that's true, it requires a higher level of service than other plans. In my belief, they should be giving the highest level of service to this least preferred plan, which means that if a child has got this plan because they're not adoptable or nobody will establish guardianship, what are they doing for the child's well-being? What kinds of counseling? What kinds of services? What are they doing to help that child to be able to move to a higher level of permanency? What kind of relationships are they establishing for the child or securing for the child? There's a book put out by the American Bar Association on unreasonable efforts, and one of the examples that I love in that book always makes me think of this APLA goal when I think of what kind of level of service we should be having. And this was a kiddo who was in residential treatment, had no one visiting him, had very high behavioral issues and problems, had been determined to be non-adoptable, just, almost going to be one of those kids that ages out of the system. And what the caseworker in that case did was find out what the child's likes were and interests, and found out that the child really liked to cook. So the caseworker worked hard to establish a relationship with the cook in the residential treatment center, had the child working in the kitchen, doing something the child liked, with a person who became like a mentor to the child, started nurturing that relationship. Pretty soon, that cook was serving as an at-home visiting resource for the child on weekends. That was supported. Eventually, and it almost makes me cry every time I think of this, that cook adopted that child who would have had nothing. But it took significant work to establish a relationship for that child, a reasonable effort to find someone that the child could connect to establish that relationship, to nurture it so that that child did have someone that was willing to commit to them in their life. That's the kind of reasonable effort we should be looking for in APLA cases, in my opinion. So an APLA plan describes how permanent ties with family members will be established and maintained. So again, sound like a broken record, but have we looked for relatives? Have we established relationships? There's been study after study that has shown that many of these kids that have APLA plans, who are residential treatment, high behavioral needs, even some that are suicidal, that when there are established relationships, their behaviors get better. And it can be as much as someone that's sending them a card on their birthday and writing to them regularly, calling them on the phone, making some kind of coming up and visiting the child. I can give you all kinds of research that shows what effect that has on stabilizing behaviors and helping a child get better. So there are two types of APLA plans in the new policy. One is APLA Permanent Foster Care, and the other is APLA Permanent Connections and Support. How many of you have seen permanent foster care cases? Are those permanent? How many of you have seen permanent foster care cases disrupt? Sometimes I think that we fool ourselves into thinking that once a case is labeled permanent foster care, that everything's going to be fine. The child has a permanent family. But they very often aren't permanent. Just because there's been a piece of paper signed doesn't mean that when the child's behaviors escalate or other things come up, that that relationship is going to be the same as a guardianship or the same as an adoption. The permanent connections and support part of APLA is supposed to do one of two things. It can be either preparing a child for emancipation or independence. So it's those children who are living independently with still with subsidies through the agency that are helping to establish all those services. Or it can be those kids that are in psychiatric or residential or DD placements and will not be discharged from there until DHS dismisses custody or the court dismisses custody. Those are the kinds of kids that we should be seeing in APLA plans and trying to get out of APLA plans. How many cases do you think are APLA plans in Oregon? What do you think the percentage is?
25%.
Yeah. 24% was the latest figures I saw, that 24% of our kids have APLA plans, the least permanent plan that there is. And in fact, federally, it's not even considered a permanency plan. Federally, permanent foster care is not recognized. I think we're the only state that even has such a thing as permanent foster care. So we really, when we're looking at these cases, need to look what kinds of efforts are being made in order to move these children to a higher level of permanency. What connections are we establishing for them? What services are we getting to help them to stabilize, to help their well-being?
So are you saying that at least 24% of our kids in custody are age 14 or above right now?
No, I'm not saying that. I said that they have APLA plans.
So, but kids under 14 don't?
Oh, yes, they do. You're not supposed to have APLA plan for a child, I think, under the age of 12, I think is what the cutoff is. But we see APLA plans for 6-year-olds, 5-year-olds. So,
we adopted a child out of foster care that was on an APLA plan, and the foster parent she had and the CASA that she had objected to it. They went to a CRB meeting, and the CRB said she's unadoptable and blah, blah, blah. And the CASA went, excuse me? And the foster mother went, no. So then they pushed her into a counseling thing. You know, she didn't want to do it, counseling, but she went through a counseling with someone who actually explained to her that she had a choice and she could be adopted.
Yeah.
But I see the APLA thing all the time, and that's that's the reason why I volunteered for CRB, was because I was sitting on the other side of the table when, after she was placed with us, where they had changed the plan. And I'm like looking at the CRB board saying, how could you ever have labeled this kid as unadoptable? Because she's not.
Yeah.
But my question is how, I know we just keep throwing this stuff back at DHS to do the relative search and find these resources, and I've even brought this up, but they, say there's privacy issues or whatever, but I have access to the files. Why don't they, or is there any counties that are doing any volunteer work to search out relatives and connections for these kids?
She asked, are there any counties that are doing volunteers to search out relatives for connections for these kids? I'm from Tillamook County, and we do have a volunteer program that is doing our file mining and our relative search and our family search for kids that are in APLA plans. Pardon?
It's not against DH policy to
No, no. There are many of the, have you heard of the safe and equitable foster care reduction teams around the state? There are 11 of them now. They formerly were called the Casey teams. They're supposed to be looking for 5 goals, meeting 5 goals. One of those goals is placement with relatives, and there are at least 6 counties that I know of that have these family search programs that are not just within DHS.
Yeah, because
Coos uses Family Find, but there was a CRB member who volunteered to work in that program, and she was declined because they felt it would be a conflict of interest, which is a little hard to understand, but
She was saying that Coos County has a Family Find program, but they wouldn't accept a CRB volunteer because they thought that there was a conflict of interest. Who was they? I mean, who is the...
Well, the CRB member told me that DHS declined to have her do voluntary work on Family Find because she was a CRB board member, which I would think would make her more diligent, possibly.
Yeah, I don't know about that. I know that many of the family search programs are CASAs, have CASAs that are doing family search. So I don't know why they would decline a CRB member. You of course would have to you would have to recuse yourself from sitting on any case where you had been doing any kind of family search or any of that, but I don't know why that might be. I've never heard of a policy saying that a CRB member could not be one, but so I don't know what that is.
The Art Gallery here in Lane County, I've done family finding for them, and there's a lot of CRB members that are doing that work. In fact, we make very good family finding people because we're more familiar with the case notes and what the case plan looks like. Lane.
Well, and in fact, I just was at a Tri-County CASA training where the person that started the Art Gallery, Christy Obie Barrett, came and spoke, and she said that that program will now do recruitment for anyone in the state that refers a family to them, or will do family searches on anyone in the state that refers it to them, any child, yeah.
Does the referral have to come from DHS, or can it come from CASA?
I don't know. I imagine that you would need to have DHS involved because all of the information in the child's file would be there. So, but I know that there are many family finding programs.
In your case, in your CRB case, that they contact a family finding organization. Yeah.
Yeah, she's recommending that you make that one of your recommendations in your CRB review.
I know this is a side issue, but in Lynn County, the DHS has a specialist who does nothing but relative searches. How is that different from what they do in Lane County?
Well, what family finding does is it opens it yourself up to a lot more search engines. It's a lot of digging to find. You're supplied with just a certain amount of information about the case. You go through the case yourself. You sit down and go through the case and see what you can pick up in terms of other relatives through the paperwork. And then you literally sit in front of your computer at home and you search all these search engines and try and find something that matches. Once you have those,
their goal is to...
My local office is doing that, right? You're assuming that they're...
No, these are separate from the relative search programs. And the family finding programs, their goal is to find 40 relatives for a child.
It's just more energy and more depth. I mean, you can get into it more depth and you've got more time devoted to that.
Than the person.
Yeah, than the person in the department who's got, 50, 100,000 cases that they have to try to find relatives for.
So, in order to develop these attachments and relationships, it's important that we look at each parent. I don't know how often we only are looking at maternal relatives and not at paternal relatives. There's a whole other side of the family, so we need to be looking at both. Siblings, other family members, advocates, substitute caregivers, past substitute caregivers of a child. And any other person who provides that continuity, belonging, stability that the child may need. They actually, in some of the family finding counties, are doing something called mobility mapping, and it started from the Red Cross. They found that one of the most pressing needs after a disaster, like a tsunami or something, was for people to reconnect with their family. And they've actually started, they actually piloted a lot of programs for how to find family members. So mobility mapping, when a caseworker does that with a child, is they sit back and they try to ask the child questions about throughout their life, like where did you live when you was in first grade? What kinds of things did you do? Do you remember any coaches that you had? Was there a church that you went to? Did you have neighbors? When where did you move from there? What were your connections there? And they actually take them through this process of identifying all kinds of extended resources, neighborhood coaches, Boy Scout leaders, whatever that might be able to be that enduring, caring connection for the child. And it's not about placement, because a lot of people, if you just talk about placement, you cut off a lot. When you talk about connections and support, people are much more willing to provide that connections and support. And it may be just like providing pictures to the child of when they were a baby. Do you know how many of our foster kids don't know what they looked like as a child? Don't have those kinds of things. So it's extremely important, the attachment and the relationships. Also, you want to take care of all the other, well-being measures and any kinds of services that might lead to a more preferred permanency plan. I really feel passionate about these APLA plans. It's one of the hardest things, I think, is to have a child who we've given up on, who we haven't even found any connections for them.
Don't you think the APLA numbers would be significantly higher if DHS actually took teenagers into jurisdiction. At least in our county, the DHS has been extremely reluctant to take any, they don't take teenagers into care at all.
Well, the safety plan, or the safety model, was supposed to remedy that not taking teenagers into care, because the safety model is supposed to be based on the safety of the child, which takes into account the vulnerability of the child and the parental capacity and all of that kind of stuff.
They use the model as the excuse to not take them in because they can remove themselves from the imminent danger, although then they get reported as runaways and drugged back home. But so I guess there would be a lot, APLA would be a lot higher, or we'd have a lot more teenagers into care, and that number would shoot significantly up from the 24%.
Could very well be. Could very well be. But you can move the case forward because you can ask questions in the review about exactly specifically what kinds of connections and supports have they looked for these children. So let's...
And thank you, Sherry. So I'm looking at the time, and I see that we have 4 minutes left before our session is over. So I'm going to ask you all, do you want to spend those 4 minutes trying to go through this scenario and coming up with questions, or do you want to take what you've ascertained from this finding and go home and kind of digest things? Yeah? Okay. Yeah. Well, really, yes.
I'd like to hear Sherry summarize for us how, are there any different questions we would be asking on the APLA scenario?
Questions to ask for APLA.
Right.
Yes, I would be asking whether or not they have, what they have done to establish connections for the child or maintain connections that the child has. What are the child's needs and what are they doing to address those needs? Are they meeting the child's mental health needs? Are they meeting the child's, other well-being needs? Very specifically, questions about what that specific child needs and who they can put in that child's life.
And just to add to that too, I think that that's just terrifically important too when we're looking at children who are in residential care with a really high level of needs. And how many times have you been in a CRB review and it's a permanent foster care situation, and well, actually it would be under their permanent connections and support, but it's sometimes it just kind of sounds like this kiddo is in residential care and somebody's thrown away the key and they're just going to stay in there forever and ever. So those are questions that are just really important to keep bringing up. Who are their connections? How are they able to enter that case plan? Is there anyone available who can be in a child meeting with their team? What kind of wraparound services are included? Is there family counseling? Is just all of that? Just continue those questions at every review and move the case forward with your recommendations.
You've been a terrific audience. I know it's late in the day. You do such great work. Go out there and ask those questions and make those recommendations.